Hello everyone. So I'm making these videos and there will be a combination of videos. I'm making these videos. Why? Because I want to share my notes. I have decided that whatever notes I have made for prelims as well as for mains, so I'll be sharing those notes. So first in the series is polity notes. So what I'm doing is I'll make different videos, a series of videos which will be covering all the notes which are important for UPSC prelims in polity, like, and it will be what do you say, covering static as well as dynamic portion whatever I made, and then I will tell you what add-ons you need to do or whether you need to do add-ons or not. And there will be certain, you will see a pattern. So what are these videos containing? So these videos will be containing what they will be containing. So these videos will be containing different what do you say, Hindu articles which I have read, the notes which I have made from those Hindus, right? Apart from that, I have given different test series, and in test series we do make repeated mistakes, like in, I will tell you, like in or national emergency provisions, or like when we talk about prohibition, certiorari, quo warranto, all those things, or different pardoning powers of precedent, what is the difference between remission, respite, reprieve, all those things. So I have made these notes. So this is a 53-page note. It's in a PDF format. I will just share with you and we will discuss these codings and notes. And I will also share with you, if people want me to share these codings and notes, I will share these notes with you. So I will you can just send me a WhatsApp message. I will share the number in the description. So I will share these notes. So, but first of all, we'll discuss these notes and we'll discuss this in the voting say. I will tell you what are the things which are very important from exam point of view, and what are the things, how they will ask you questions, how they, because the way UPSC asks questions, it's not the same way the other exams ask questions, right? Like this question, and different test series also. You will give different test series. I won't name them, but different test series you will give, you will see there is a different definite pattern which they are asking, like this particular question, union of Trinity. So what happens, they will ask you that Ambedkar described what as union of Trinity, and then they will give you FR, DPSP, FD, and all those things. But Ambedkar actually described liberty, equality, and fraternity as union of Trinity. So this way, I will share all these notes. It's a 53-page notes for polity for prelims, and there are separate notes for mains also. And what I have done was, or what I had done when I was preparing. So what I did was I even took out, like when you will see the prelims or mains syllabus for GS2, you will see there are many overlapping sections, right? So yes, I have taken out those materials also, which I thought was important from pre-point of view. So this was about Union of Trinity. Don't forget, liberty, equality, and fraternity are called as the Union of Trinity. It was called by Ambedkar. Now, if we talk about constitutional amendments, right? So there are many things which are important from constitutional amendment point of view. What is the thing that there is no, or if you talk about different amendments, right? So there is no joint sitting for constitutional amendment, right? And we do know that president has many power, like we have talked about. We know about, if you have left voting is read Lakshmikant, you know about suspensive veto, absolute veto, qualified veto. What are the vetoes which are applicable in Indian context? But in the case of constitutional amendment, president has to give his assent. He cannot withdraw his assent, or he cannot. What do you say? Even he can neither withhold his assent, nor he can return the bill for reconsideration. So there are too many restrictions in the case of constitutional amendment in the, what do you say, for president, and he has to give his assent. Now, again, the thing which I want, why I made these notes, because there were different questions framed on these amendments. So be very precise. Now, the third thing which is related to amendment is Article 368 provides for only two types of amendment. What are those two types? Special majority, which is 50% of the total membership of the House, plus 2 by 3rd present and voting. So this is special majority, one scenario. The second scenario is special majority plus ratification by half of the states, right? Now, there is third kind of amendment also, amendment by simple majority, but they are not deemed to be amendment under Article 368. It is very important. You have to understand this, and this is important from prelims point of view. And from mains point of view, what is important is we'll deal with that separately. You will see that you have to, how they can ask the same question in mains also, right? Now let's move on. So now, what are the amendment? Even then, they can give you certain questions like establishment of states and all those things. It's an amendment by simple majority, special majority, or special majority plus ratification by half of the states. So you need to remember some of them, like establishment of states, where you're altering the state boundaries, etc. It's a amendment by simple majority, which is not deemed to be an amendment under Article 368. Similarly, creation of legislative council in states, it is not deemed to be an amendment under Article 368. Second schedule, which deals with allowance and privileges, along with fifth and sixth schedule, they are also, if you're doing any amendment, it's amendment by simple majority. When you're doing delimitation of constitution, this is interesting. Delimitation, we have seen also, and when you will read Lakshmikant, you will know that delimitation is not subject to judicial review. But even here, if you're making any amendment, that amendment is by simple majority, which is not deemed to be amendment under Article 368. Similarly, in the case of citizenship. The fourth important point about amendment is Special majority, we have talked about. Now, there are two kinds of special majority which are deemed to be amendment under Article 368. So these are the two types: special majority and what do you say? What was the first scenario? This was the scenario, na? Special majority, that is 50% of total membership present and 2 by 3rd present and voting. So ratification by them. So in this case, what are the things which are lines? FR, DPSP, if you're making any amendment in fundamental rights or in DPSP, so they will be coming under the consideration of special majority, first type of special majority. And all other provisions which are not covered in first and third category. First category was simple majority and third category is this, special majority plus ratification by half of the states. So if we talk about the second scenario, in this case, election of president, that will involve, if you're making any kind of change in the pattern of election of president, that will involve special majority plus ratification by half of the state. Second scenario, if you're making any changes in Supreme Court or High Court, what do you say? Powers and all those things. Similarly, when you're making, this is a federal scenario, right? This distribution of legislative power between union and state, obviously, even if you don't know it, you will understand that it will require ratification by half of the state. Similarly, 7th schedule, which talks about union, state, and concurrent list, and Article 368 itself. Apart from all these things, what you need to remember is, so this was about amendment. Similarly, why I have written Article 50 here, this is a separate part. There was some mistake which I did in certain test series related to Article 50. Now, what does Article 50 says? It is under DPSP, Directive Principle and State Policy, and it is talking about separating judiciary from executive in public services of the state. And for giving, what do you say, for implementing Article 50, CrPC 1973 came into existence. So, what do you say? Criminal Procedure Code 1973 is giving a realistic favor or is implementing the provisions of Article 50, which talks about separating judiciary from executive, separation of power. Now let's talk about Article 35A. Very much in news, has been in news from last 1.5 or 2 years, right? So it was incorporated in. Now there is a very major controversy regarding Article 335A, that it was incorporated through a presidential order issued under Article 370, right? But Article 368I, this you can use in your mains also, and we'll read 35A from mains perspective also. 368I is saying that whenever you're making any such constitutional amendment, only parliament can do it. You cannot do it through a presidential order. So that was a dichotomy, right? And only you can make these amendments only by parliament, and parliament can amend the constitution by introducing a new article. So that was the scenario, or that was the case. Now let's talk about preamble. Now here also there are many things which they can ask in prelims. First of all, Jurist N.A. Palkhivala, he said that preamble is the identity card of the constitution. So they can ask you, and they had asked you in different exam, that Jurist N.A. Palkhivala, he said, whose full name was Palkhivala. Jurist N.A. Palkhivala said what as the identity card of the constitution? It is preamble. Now it is based on objective resolution. Again, the question has been asked in the past. Objective resolution was drafted by whom and moved by whom? Nehru or Jawaharlal Nehru. So now 47th constitutional amendment, they added these words. This is very famous question. They added these words: socialist, secular, and integrity to the preamble. Now, what does preamble learn? These things are not important. Now, second part is important. The justice, social, economic, and political. We have these words in preamble. They have been taken from Russian Revolution. Now, this part which is important from main's point of view also, or maybe because UPSC is going very unpredictable these days, so they can ask you this pattern also, that in Berubari Union, they had said, the Berubari Union case in 1960, it said that preamble is not part of the constitution. Whereas in case 1 and Bharti case, which happened in 1973, the same year when Sachin Tendulkar born, so they said that this preamble is a part of the constitution, right? Now, we will keep until here only. In the next video, we'll talk about inner line permit. What are the provisions? We'll talk about GSPSC, Joint Public Service Commission. What are the scenarios here? Because again, we make maximum mistake in this one. So we'll talk about all those things, right? And we'll continue doing that. So I will share these notes also. If you want these notes, you can just send me a WhatsApp message. I will share the number in the description, right? So that's it. Thank you.